Hello, I'm Catherine McGregor, Publishing Director of GC Magazine, and welcome to Trusted Advisor, where we discuss key business developments and trends with law firms and discuss how they're best serving their clients in the midst of these. Joining me today is Mark Sweet, Managing Partner of Finnegan. Finnegan is a leading global intellectual property specialist. So Mark, thanks so much for joining me today. I'd like to start off by discussing the fact that over the last 20 years, the role of the general counsel and the in-house lawyer has changed and developed a lot. Can you tell me how outside counsel like yourself are best responding to these changes? And specifically within the IP practice, are there any adaptations you've made?
Sure. Well, thank you. And thanks for meeting with me today. We have had a lot of changes with the business of law, really, in the last 8 to 10 years, particularly with what happened in 2008 with the financial crisis here in the United States. And it has caused a lot of our clients, the GCs and the in-house IP attorneys, to really have a business focus much more than they used to. They would always be lightly guided, I would say. And after the 2008 financial crisis, there was a lot of pressure on all departments within the company to cut costs and control costs and to strategize about what was important and what was not. So we have seen a tremendous business focus from the legal officers in these companies, and we've had to really adapt our role and re-emphasize our goal to be a true business partner with our clients. It's not just giving the best legal answer. We also have to consider what the client's business purpose is when we're doing that. And that's a role that we'd always done. That was one of the goals of Finnegan, to be very integrated with our clients and be part of, feel like we're part of their legal department and corporate structure. But with what happened starting in 2008, it really reemphasized the need for us to understand what our clients' business needs are, to communicate about those business needs, and to be able to provide legal answers that would achieve those business objectives.
IP is obviously developing a lot. The product cycle has been decreasing. We've got the increase of automation and the advent of artificial intelligence. Are there any particular trends that are affecting all industries that you think all general counsel should be alert to? And also, are there any particular developments that are affecting some industries more than others that clients should be alert to?
That's a really good question. The beauty of the IP business is that it's a very dynamic business. Things are always changing. The technology is changing that we're trying to protect. The law is changing that we're using, to our benefit to protect our clients' technology. And the business is changing. People's business objectives change all the time, particularly with a lot of the mergers that you see and the way that the new technologies affect those businesses. So there are a lot of moving parts in the IP business, and that's very exciting. And with that, there are many, many changes over time. In the late aughts, you had the cell phone wars, and that was the big hot technology. Those have now all been settled. Those aren't going on anymore, but the technology continues to expand from the 3G coverage to the 4G coverage, and we have 5G coverage coming down the road. So that's very exciting. Who knows, maybe some laws will change because of that. It certainly affects the standard setting practice that's involved in the electronics industry. What's hot right now, where cell phones were hot 10 years ago, we really have the biologics and biosimilar areas. There's a lot of things going on right now. A lot of companies are dedicating resources to research and development in this area. We've had changes in the law with the BPCIA that came into effect in 2010 that allows companies to do work and market products in the biosimilar area. We just recently had a Supreme Court decision, which in the IP field is a big deal when we get cases decided by the Supreme Court. And this recent case lowered the bar for what companies can do with respect to biosimilars. They don't have to do as many disclosure requirements, so it allows them to get products on the market quicker, or products into the pipeline quicker. And that's where, as one specific industry where we expect to see a lot of change is in the biologics, biosimilars area, because there's a lot of products in the pipeline, the product pipeline, which is going to lead to more FDA applications, which is going to then lead to more lawsuits, similar to the ANDA lawsuits that we have now. With the Supreme Court case that I mentioned to you, it's going to cause the time frame to be shortened on that. What would have taken 8 to 10 months now could happen in 30 days. And then as a result of all of that information and people filing new applications and then the resulting lawsuits, there's also an invalidating procedure at the Patent Office called IPRs, inter partes review. And that's what people use to file at the Patent Office in an invalidating proceeding before somebody's patents. And it's a quicker, less expensive version than a litigation. So we're going to, I think, with all of the applications that'll be in the pipeline and the resulting litigations that may occur, another thing that will happen is that there'll be more of these IPRs filed at the Patent Office. So that's an example of where you have this new technology, the biosimilars, the new law, the PCIA coming into effect, and then how do people want to deal with that from a business standpoint? It all comes into play.
So this is definitely something that GCs need to keep aware of and be aware of the developments in then, Mark.
Yeah, most certainly.
That's great. Thank you so much for joining me today. And thank you for joining me for Trusted Advisor.